Well, hi everyone. I'm John Deary, and welcome to our video legal podcast. We have an interesting topic tonight, and that is an attorney who does something that not that many attorneys are able to do, and that is to work on both the defense and the plaintiff side in civil action, civil court. And he's someone that I've been a personal friend for 20 plus years. So I'm really delighted to welcome Tim Jones. Tim, so good to see you.
Thanks, John. Good to see you too. Great to be here.
As I said, there's not a lot of attorneys that fit into your category as it relates to having represented both the defendant and the plaintiff on civil cases.
Right.
Most are either one side or the other, as we are on the plaintiff side.
Right.
So I'm very interested. First of all, let's start by saying, how did you get into being an attorney representing both sides?
Well, when you get into civil litigation, there are two sides: there's the plaintiff or defendant.
Yep.
And when you first come out of law school, for me anyway, most of my family had been on the defense side, and I wound up there. But I gravitated towards the plaintiff side probably in the mid '90s through the early 2000s, as you know.
Yep.
And then for the last 16 years, it's been exclusively defendant, but it's got its dramatics on both sides of the equation. Yeah.
Well, it's an easy question to ask, and that is that which of those kind of practices, plaintiff or defendant, do you enjoy more?
Well, I got to say, regardless of the side you're on, both provide their challenges. In a courtroom, both provide a lot of dramatics. You get to cross-examine more as a defendant because the plaintiff has to produce arguably more witnesses, and so it requires a skill set to prepare cross-examinations, sometimes quickly, sometimes based on records you haven't seen. So I think in terms of the ability to cross-examine, you need to be a little quicker off the draw on the defense side.
Give us an approach on both sides, because it's interesting, and that is that what you get a case, when you were doing a plaintiff's work, you get a plaintiff's case. Just give us a couple of the key steps in moving a case forward when you're representing a plaintiff.
Okay, and I found it very helpful, when I'm on the defense side, to look at what a plaintiff has to do. They had to prove the elements of their case. And in our field, personal injury, most times what they're looking at is, one, liability, which has the VTL and sections like that. They need a VTL or common law type of violation to prove negligence. And number two, on the damages side, they've got to prove serious injury. So I have to look at it. If you're a plaintiff, you got to say, what are the elements that I need to prove to qualify for serious injury, and they're in the jury charges, and you take your case that way, and you proceed and build your case based upon those elements. And it sounds elementary, but you got to make a jury understand it, and that starts in jury selection.
Defendant side.
Defense side, well, by the time you get to trial as a defendant, the plaintiffs are already on third base waiting to score. You've already had the accident, and you have probably a plausible case of liability. Most times, the plaintiff has already had months, if not years, of treatment, and in 90% of the cases, you're going to see a surgery. So, as a defendant, how do you push that back? Because it's very impressive to a jury to hear about the circumstances of an accident, possible emergency room care, physical therapy, chiropractic care, and possibly surgery with general anesthesia. So what's a defendant to do? How do you prove that's not a serious injury? And that's the challenge. And it's very challenging, and that comes, and you push it back with cross-examination. And that's where the real challenge comes in, because the plaintiff has already presented his or her case and presented their plaintiff, and the plaintiff is saying, the doctor says I needed a surgery. And I underwent the surgery, and now I'm asking the jury for compensation. So it is very challenging in a sense if you're tasked with the objective of winning on threshold. If you want to send the plaintiff home with no money, that's a formidable task. Or you can look at it and just try to beat them in categories of damages, try to eliminate future, try to eliminate future wages, try to eliminate other components to keep that damage award low. So plaintiff side, prove your case, meet your burden, get your plaintiff up there, get your expert on the stand, establish causal relation between accident and injury. Defense side, push them back. Try to beat the serious injury threshold charge.
From a plaintiff's perspective, how would you characterize or categorize, I'd say, the type of cases that you represent?
Well, in the plaintiff's field, I've had, breast cancer, medical malpractice cases, labor law cases, auto, premises. Pretty much, run the gamut of all types of cases, and each have their categories of damages and the different burdens of proof in some respects. But those are the kind of cases I've done on the plaintiff's side.
Trying to evaluate, I'm going to ask you on the defense side, but trying to evaluate, what do you consider to be the most challenging cases on a plaintiff's perspective of those type of, as you say, malpractice, construction site, et cetera, premises?
Certainly medical malpractice.
The most challenging?
Most challenging for a plaintiff because there's a sentiment among people, which includes jurors, to believe your doctors. And, there's a high percentage of cases, medical malpractice, that just go the defendant's way. Mm-hmm. And it's a pretty tough burden to ask a jury to conclude that the doctor deviated from accepted standards of medical practice when he treated and cared for a patient. So those are tough. I found those to be tough. And the defense attorneys in med mal cases are good. Every one of them is good. And they cross-examine well, and those are probably the toughest cases to prevail on.
What kind of communication, I want to stay with, for the moment, I want to stay with the plaintiff's side of it. Mm-hmm. How much communication do you have with individual clients?
Well, as a plaintiff, your client, you have to direct the client on the stand. In other words, you can't give him or her the answers to the questions. It's not a cross-examination. So the communication is critical in the sense that the story has to be, and the version of events has to be consistent. And if you find yourself being tripped up, for instance, on a witness stand, and maybe the plaintiff freezes on a stand, doesn't know what to say, the more you communicate with your client, and the more you establish the goals you want to attain and know where you need to be at the end of the case, more communication leads to a better result. So you have to be in close communication with your client frequently, not just in the hallway before you get on the stand. You have to know what the objectives are for the case, and what in a personal injury case, you have to know what the charge is. You educate your client as to what the jury is going to hear, and the testimony has to include those components of the case. Otherwise, you could lose it.
What's your communication issues with regard to the defendants?
Well, the most important witnesses for the defense side, aside from the defendant, if you have a liability issue, is our physicians. And most times, we're talking about volumes of records. And a common course of cross-examination for either side is to show that witness, meaning the expert, what he or she doesn't know. Well, were you aware of this? Were you aware of that? So what's most critical is that you go over with your expert all the records he or she reviewed, so that when called upon on cross-examination, you can honestly state, yes, I did review that. And if for any reason the content of one record contradicts a conclusion, there's got to be an explanation for that. So if we have an emergency room record where there's no complaints of shoulder pain, for argument's sake, but the plaintiff winds up with a shoulder scope, your cross-examination, your direct examination, I should say, with your own expert, you have to go over that. Well, there were no complaints in the ER, hence I don't think there's a causal relation between the surgery and this accident. So you both had to rehearse and be able to call upon the content of those records quickly, because the jury wants to hear it quickly. So,
You enjoy trials.
yes, certainly.
Why?
I would say in a typical personal injury trial, you're going to see every single human emotion. You're going to see anger. You may see some honesty. You may see a lot of dishonesty. You'll see happiness. You'll see sadness, because someone's going to lose, unless the case resolves or settles, which not everybody's happy with that either. But yeah, in a capsule, in one courtroom over the course of several days, you'll see several emotions. You'll see a lot of drama, pushback, a lot of sportsmanship, you know, and so in that respect, it's challenging. It's quite a chess match, particularly in our field. You have a lot of people. It's a small industry where you see the same people try cases, and you know, it's very enjoyable in that sense. You know, that you get to evoke those types of emotions, and from the attorney standpoint as well, you get those emotions. You get angry. You want to push back. You want to have, you know, you want to prevail. You know, and so I think in a very concentrated way, you're experiencing every emotion in the terms of a week or 10 days, however long the case may last.
Considering, again, both plaintiff and defendant, which is the most challenging in a trial setting between those two, coming at them with the defendants or the plaintiffs?
The most challenging is the defense side. And the reason I say that is most of the evidence that a jury will see in terms of documents, photographs, medical records, surgery records, support the plaintiff. So if a jury asks for records, so to speak, just assuming just a damages only case, everything they read is going to support the plaintiff's version of events. How do you beat that? Because our expert reports, meaning the defense, don't go into evidence for the most part. So you have to leave the jury with enough of an impression based upon cross-examination that what's in the content of those records doesn't qualify for a serious injury breach, and the plaintiff should go home with nothing or a fraction of what they may be asking for. So when I use a baseball phrase that they're on third base ready to score, they are. Mm-hmm. You know, by the time they show up, they've got a surgery, they've got most likely liability in some respect. And so in order to push that back, it's an enormous and formidable challenge as a defendant, I find. You know, on the plaintiff side, I felt as if you were presenting the case and then you're leaving it to your adversary. Okay, cross-examine the material. Try to beat what we put up in front of you.
I know that you tend to work a fair amount in the Bronx and cases in the Bronx.
Yes.
What would you say is your overall experience in terms of plaintiff or defendants, in terms of successes you may have from a practicing perspective? I'm not saying you just necessarily individually, but which seem to prevail?
The Bronx is primarily known as a plaintiffs-oriented venue. All right. And that's been the case for decades. And I've always, even in, you know, when my father was coming home, he worked in the Bronx, so he'd say, "Oh my God, I'm in the Bronx again today." And, you know, he was defense attorney in the Bronx. And I was like, what is this place, the Bronx? I didn't know it was like this horrible place, you know.
A Queens guy, we might add.
Yeah, exactly. So I was, but as I have tried cases there, I've had a fair amount of success. I've had a fair amount of, you know, what I consider not success. And it all comes back to the jury. And I know that's saying a lot and it's saying nothing. But, and the jury's experience, because sometimes you'll question them in the hallway about the result they reached, and you're like, that wasn't evidence at trial, you know. And for example, There was a juror I spoke to on a case where I thought a large amount of money was awarded, too large, and I said, well, what was your thoughts on that? She said, well, she broke her arm as a child and it never got better. And I said, you know, you didn't mention that in jury selection, and you know that's got nothing to do with the case. So you exhaust them, you know, during jury selection. You think you've asked them everything that's supposed to have occurred, but you can't ask enough questions on jury selection. You have to keep digging. I mean, you only have a limited amount of time. I do think Bronx jurors are very street smart. If you have a premises case, you have to be aware of the fact that most of the jurors are going to be tenants. They're not landlords. And if you represent a landlord, well, you've got a problem, you know, and because they're going to see the face of their landlord, you know, at the course of a trial. If they have a problem in their apartment, they may take it out on you. Auto cases, I find that they are skeptics, but they can be persuaded. You know, they don't always just buy the fact that someone's saying they can't work the rest of their lives, or they can't, or they're seriously injured. They are open to common sense if you present it, and I try to find that. You know, when I try a case on the defense side, I look for a quote-unquote defense, and they're not easy to find. You know, but that's what I look for, because, like I said, most of the material is overwhelmingly in favor of the plaintiff. So.
Most individuals are aware of the term jury and know that they are decision makers and they listen to the case when it's in trial. I'm interested in the process of explaining how do you go about making decisions with regard to juries, whether on the plaintiff or defendant side?
Well, you want people with life experience, who've handled a dollar, who've had a job, or currently working, on either side of the equation, all right? You probably don't want somebody who has no work experience, hasn't had a job, doesn't know what's, you know, and you can get jurors 19, 20 years old, and you've got to be cautious with them, and you've got to ask them extra questions.
On the defense or the plaintiff side? Both.
But the plaintiff would probably want that person, because that's one less vote they got to worry about. That person may just go along with the crowd. So that's a cautious type of juror. Now, you only get 3 challenges. So if you can't get them to talk them off themselves, you know, you may have to burn a challenge on such an individual.
Explain that you have the 3 challenges. Explain that. That's important.
They're called preemptory challenges, and each side gets 3. And if there's 2 defendants, you share 3. As a plaintiff, you get 3. And so if you have a juror that is giving answers such as, number 1, I've had a prior lawsuit, I have a bad back and it still kills me and I'm still going to the doctor, and you ask that juror, well, you have a similar injury to the claim of the plaintiff. Do you think that would make you favor the plaintiff? You say, oh no, I can be fair. That's what this juror says, but your instincts will tell you, you know what's coming at trial. And if that juror is going to be, oh yeah, I got that too, and I'm in pain for the rest, you can't have that juror on your case. And if he or she says, oh, I can still be fair, you know, a judge may, and if you bring it to a judge's attention, a judge may say, well, you may have to burn a challenge on that person because he or she said they could be fair. You could try a cause challenge, doesn't always, you won't always prevail on that. It depends upon the judge that is hearing the issue. But critical components.
You have a trial. It comes out plus for you or negative as the case may be.
Yeah.
Are you able to speak to the jury to get their perspective of how they analyze the case?
Absolutely.
Do you?
Yeah, for the most part, yeah. You're actually going to run into them in the hallway at the same time, sometimes in the elevator. Now, you'll find sometimes the jury just wants to pack up and go. If they've been there too many days or they're upset with the presentation by one side or the other. Other times they'll hang around and they want to talk about it. And those can be educational moments. Maybe sometimes as the attorney, you don't want to talk to them, depending upon how it went. But for the most part, I have found it, you know, educational. The judges will usually invite the attorneys to speak to the jurors because for a couple of reasons. One is the public relations thing. I mean, you spent a week so or 10 days with these people, and now the judge may not want you just to disregard them. If they want to speak to you, you should hang around, and I would agree with that, because now you can speak to them again. You haven't spoken with them since jury selection, and you made that clear to them. You can't even look at them in an elevator. You got to walk away from them. So they may want to present, and it's always the winner that wants to talk to the jury.
Yeah.
Hey, wasn't I great? So, but sometimes, if you had a bad result, those attorneys, may want to ask, what were you thinking?
Win or lose, what are you seeking to learn by communicating with the jury?
I try to divorce the result from, how I may feel about my presentation, although it's difficult to do. I try to be as prepared as I can be. But to answer that question, I guess what you want to say is, I'd want to know what piece of evidence persuaded them. What were they looking for that made them rule one the way they did? And sometimes it's got nothing to do with the medicine, nothing at all. It could be a very quirky type of circumstance. And a quick story: I remember speaking with a particular witness who said that she couldn't speak English, and she was, on the phone, and she was talking at the time of the accident. She said to the police officer, that she, all in English, the whole version is in English, and she's on the stand. She says, no, she needs an interpreter. I said, okay. We prevailed in that case, and some years later, I was walking up 161st Street, and a juror starts yelling my name. Said, "Hey, Mr. Jones, Mr. Jones." I said, "What?" She said, "That woman, you got her. She did speak English. We heard her in the hallway speaking English, so we knew she was lying." I went, "Wow." So, it's interesting in that you never know what piece of evidence is going to flip them. And I had no idea until years later when this woman stopped me on 161st Street. She said she liked the experience so much she went to law school. But,
Oh, really?
Yeah.
Oh, wow.
But, as a defendant, you got to pursue every angle you can. And to me, I thought that piece of evidence was significant in that, for the following reason. She's taking up the juror's time with an interpreter. Cross-examination is very frustrating when I know you speak English because it's in the police report, and you didn't ask for an interpreter, and you didn't ask for one at the emergency room either. So, by the time I finished those questions, I didn't think it went anywhere until I learned later on 161st Street, some years later, that no, they heard her speaking English in the hallway.
Do you have a sense, irrespective of what the outcome of individual cases are, do you have a sense that the jury has an innate simpatico for the plaintiff, or is that an overstatement?
No, they do. They want to believe that person.
Okay. And
that's only human nature. And I'm aware of that. I know that I put that in the column when I'm trying the case of, look, they've got no reason to disbelieve this person. This person was in an accident. This person had medical treatment. This person may have had a surgery. Why not believe him or her? And so you've got to find reasons for a jury to see it your way on the other side. And that's, the side I'm on now, and I find it extremely challenging. And yes, I think the jurors have a predisposition, by all means. And look at all the commercials we see. You can't go up to Deegan without seeing a billboard, and I include that in my jury selections. It's there's billboards, commercials, and even when they're waiting for jury selection in the room, you're seeing personal injury attorney ads. So the answer is yes.
In the course of a trial, what do you, both in terms of both defendant and plaintiffs, what do you think are the most important as it relates to the client that you're representing? Which is the most important phase in a trial, I guess is what I'm asking.
Okay. Jury selection. They're the decision makers. And I tell the jury, I said, look, I know it appears as if this is our case, and you're told when to show up, and you're told when you can have lunch, and you're told when you can take a break and when you can't. But I said, ultimately, at the end of the day, when you sign that verdict sheet, this is and always has been your case, not ours. So I asked them to take ownership of it and take the the signature lines very seriously because it lives forever. And I try to take away, as best I can, the victimhood of the plaintiff. And if I can, most times, if I have my client present, if I have a liability defense, it would be unfair to this person. It would be victimizing this defendant if you were to find against him based upon and whatever evidence may come up that I may have to include in my summation. So, it's jury selection is probably the most important because they are the people that will call the shots.
Do you use demonstrative evidence in terms of your presentations?
Yes.
What type?
Shoulder models, back models. Juries want to see. The most important piece of evidence for the defense is an MRI. The actual film study put on a screen for the jury and have your radiologists explain the anatomy and what a pathology may look like, what an injury may look like, what is trauma versus what is chronic. And that's what I think is the real crux of what we do on both sides. Plaintiffs will say this is a traumatic injury, and here it is. On the defense side, you'll say, oh no, this is chronic. And what they're suing for was there years before the accident. So that's part of the arguments that arise in the course of a trial. Very common. And you have to be fluent in that information.
I'd be very interested. You touched on the classic kinds of cases, but I would be interested in just a kind of a brief sense as to how you approach it, either from plaintiff or defendant, as the case may be. A premises case.
Premises case, difficult for the plaintiff. That burden is to prove.
Why do you say that?
You have to prove that the landlord knew of the condition or should have known of the condition before liability can attach to that particular defendant. It's, I think, a more formidable burden than a typical auto case where someone may run a stop sign, be speeding, run a red light. If you have a condition which is transient, something that may have, maybe there was ice one day but not the next day, maybe it melted, or maybe the condition wasn't there long enough for the landlord to have observed and corrected. And a jury charge for a premises case, I think, is a little forgiving to the landlord. So I think in a plaintiff's point of view, that is the more formidable burden, in my estimation. What I think.
What about a motor vehicle case?
A little simpler.
From whose side?
From the plaintiff's side. Well, if you got your typical rear-end collision, sometimes the points of contact, photographs will tell you what happened. If you got an impact to the rear of a car, not a lot of explanation here unless you have a short stop type of defense. If you have damage to the side of a plaintiff's car, well, we can figure out based upon the points of contact that what part of whose car struck the other part of the other car. So you can put things together based upon photographs of vehicles to some extent. And these days with dash cam videos, it takes it can provide a lot of information to a jury, and there's cameras everywhere now, and a lot of times a dash cam video will extinguish one version of event versus the other. So I think they're a little simpler, and than the premises case, I would say.
Labor law.
Well, people love safe workplaces. The labor law as it exists now and has been, when you have something called the industrial code, we're the only state pretty much in the nation that uses the industrial code. The strict liability situations under 241.6 and 240, it's been watered down a bit. I won't get into that now. But as a plaintiff, if you have the components of a summary judgment case under 241.6 or 240, you're only talking about damages at this point, which can be profound if we're talking about a workplace injury, which, in a lot of cases, if somebody's fallen X amount of feet, fallen off a ladder, got an electrical shock, it's those damages can be profound, you know, up in the level of, you know, even medical malpractice cases, in my experience. You know, so, but the law itself has gone through a lot of, bit of a washing machine over the last 10 to 15 years, where there are some defenses to the summary judgment on 240 and things of that nature, but that's for a whole other class. But those are not as clear cut sometimes as auto liability.
And the other category, of course, is the medical malpractice.
Yes, you're asking a jury to conclude that the doctor's treatment of a particular plaintiff deviated from accepted standards of medical care, you know. And there are accepted standards of medical care, which are defined by the experts, who each side calls their own. So it's one set of experts will get on a stand and say, no, the doctor did not deviate from accepted standard of medical care. And the other side will say, yes, he did. He should have done this, that, or the other thing. He should have ordered another diagnostic test. He should have ordered, you know, a colonoscopy. The conditions were there. So the jury gets to conclude, and that's the typical and overused phrase of the battle of the experts, but there is a predisposition of jurors to side with the doctor. You know, not to say that there aren't profound injuries, you know, with med mal, they are, but those cases generally don't see a jury.
What would you say is an average typical trial? How many days generally? I don't know, of course, it all depends upon the substance of the case, but generally speaking, what is the length of a trial?
Beginning with jury selection, which takes a day, openings, direct of the plaintiff, assuming has two experts, defendant, if you have liability and damages, has two experts, a week to 10 days. And, you know, and depending upon whether a judge has other events going on, but actual time is a week to 10 days that you're with these people, 8 hours a day.
Yeah.
And if you have a bad day, you can recover. So you don't get too high, don't get too low. If you do a good job of the witness, don't get too high, don't get too low. If you had a bad day with a witness, try to explain it in your summation.
Mediation. Do you do much?
Oh, many.
More mediation than trials?
I'd say we're getting there. We're getting to a lot of mediations in the sense that we have the material. We have the plaintiff's material. Medical records are exchanged well before trial. So the industry requires resolution, and a lot of people want them done quickly. If you want to wait for your jury, you can, but you may wait 2 years. If you have the material present, you've had depositions, why not get a mediation? You know, we know what the coverage is.
What do you think is the main benefit of a mediation?
Rapid resolution, no doubt.
Are there any particular mediators or groups that you do whatever mediation you do with that group or the other?
Well, there are several that are on the panels of most carriers.
Yes.
You know, NAM, Century, Janssen, you know, there's several of them. And depending upon who's on the panel, you know, you'll speak with your adversary and say, who do you prefer? And that's very rarely is it a contentious point. You know, you're both going to find somebody that you can agree upon. And, you know, I'd say it cuts back, you know, doing a mediation cuts back in the trial preparation significantly, and it's helpful to both sides. Because on the insurance carrier side, they have a resolution. They don't have to expend hours and time and expert witnesses. Same for the plaintiffs. And the jury's the wild card. You don't have to give it to them.
A final question I have, and that is that, so you're looking at a trial as it advanced. You can go, not at a trial, but as a case. You can go trial, you can go mediation, or you can go settlement.
Or arbitration, right?
Or arbitration,
Right.
indeed. How do you go about explaining to your client, and especially if you're doing it on the plaintiff side, why do one or the other?
It's, well, with the plaintiff, the numbers are right there. The offer is X, and if you're the attorney, and I think the offer should be a minimum of this, they're not giving us any choice but to go forward. So if the plaintiff feels as if the offer is insufficient, you don't have a choice. Right? As a defendant, if the plaintiff's demand is policy limits, you have no choice as a defendant. You have to prepare and go forward to trial. So, and I find that a lot. I see a lot of policy demands from the plaintiff's side, and I think on the defense side, if the offer is insufficient, depending upon the venue, well, you run a collision course to a jury, which is common. I mean, the courtrooms are full. You can go in any courtroom in the Bronx almost every day where I am, and you'll see a trial going on, and it's for one of those reasons.
If you decide to go to trial, what's the time period, more or less, between we are proceeding forward on a trial and when we get a trial?
From when the note of issue is filed,
Yeah.
you're usually talking about a year.
Okay.
Yeah, and there'll be several conferences in the interim,
Yeah.
and the judges do try to get the sides together, and it's and then you could go summary jury trial, which is a vehicle that's sometimes used, which for one reason or the other, people like them, don't like them. I think they're very effective. So
I can tell from hearing your responses the remarkable backlog of information and experiences and trials and everything associated with it on both sides.
Yeah.
So, Tim, thank you very much. This has been very informative.
thank you, John. Thanks for having me. Good to see you.
Great to
Okay.
see you, Tim.
Okay. Bye-bye now.